Jay, let me just say I'm glad you raised that point because I wanted to address it. I agree with you on the Dillon case. The judge almost seemed to be bending over backwards the other way. It was kind of an incomprehensible ruling. One of the things he said was that because the defendant had actually used the same celebrities that had been proposed in the plaintiff's treatment, that was somehow a taking of copyrightable subject matter, which obviously it isn't. But let me turn it around on you now and say, sitting in the moderator's chair, I agree with you that the vast majority of these cases should be dismissed, and a lot of them are very ridiculous. A lot of the ones against Jim Cameron from the billion-dollar Avatar franchise should never have been brought. But do you think that in 35 years, only one case has had enough substance to be presented to a jury? Do you believe that the people in the motion picture business are such paragons of honesty and virtue that none of them are plagiarizing scripts that are being submitted to them or that they're somehow becoming exposed to?
Well, they do have unsolicited submission procedures to limit the access to unsolicited submissions. And partly, yeah, they are paragons of non-infringing works, but actually my guess is that over those 35 years, there were probably, quite a few, I don't know how many, that were settled because they actually had some merit. And why would a studio go forward if the case had merit? So I don't know how many were settled in that time period, but I think it'd be an interesting piece of data to have that would also it would suggest that not only are studios attempting not to infringe people's works, and I have been involved in cases where we were accused by another studio of infringing a screenplay that they had, and we were in a development stage, and we had to look at their screenplay and sort of decide what exactly was protectable about that screenplay, and go through our screenplay and make sure none of that was in our screenplay. And that was a case between two studios, and the other studio went away. The idea was similar at a very abstract level, but they don't own that. So, I mean, I think they do make great efforts not to infringe copyrights. Obviously, sometimes slips can happen. Creative executives or independent production companies with deals on a lot might accept material and look at material they shouldn't be looking at, and somehow there's a vague, indirect, possible chain of access to that work. But also, there's a strong possibility that any claim that had merit got settled. Just like the Frozen case got settled, by the way.
I'd like to address all those issues. So first of all, that is what the studios have been saying. They're like, oh, the good cases get settled. And that's total bullshit. You ask any entertainment litigator in this town, and what they'll tell you is because the law now is so favorable to the studios, that 9 times out of 10 they won't even talk about a settlement until they've already won. Until they've already lost either a motion to dismiss or a motion for summary judgment. So the concept that the quote-unquote good cases get settled, at least all the entertainment litigators that I've talked to say that concept is completely false. They don't care how good the case is. They know they got a 90% chance of knocking it out on a motion to dismiss or a motion for summary judgment. So they might as well spend the money to do that first before they even talk about settlement. So that's A.
So the plaintiffs are being unreasonable in the amount they're asking for settlement.
No, what the studios are doing is they're setting a precedent. They're setting a tone, a vibe, if you will, throughout the entire community that says if you come to us with anything, we don't care. We will crush you.
Right.
And they will tell you that.
Yeah.
They will say those words. We will bring every motion to bear on you in whatever form we deem. We have the power to do that. It's a prophylactic.
That's been our experience, and if you talk to any other entertainment litigator, you'll see that experience is shared.
That certainly wasn't my experience with in-house counsel at my own studio and other studios that I know.
Fair enough, fair enough.
And I've never heard them say anything as angry as what you just said. And the precedent isn't established by the studios, it's established by the courts. So.
Right. So that's number one. Number two is I have actually got sort of some inside information that what some actual studios do is this. They take the scripts that come in, they give them to their coverage department. If the coverage department gives it a favorable rating, they then give the summary to another writer to write the actual screenplay. What are they using? Just the ideas, not the expression of the idea. So it's actually institutionalized. And by my person, if I just from what I've been doing this for 30 years, and if I had to estimate, I'd say about 50% of what you see on TV and movies was taken from somebody else. And I don't mean just, used as inspiration for something else. I mean actually stolen. And the reason that it's so rampant these days is precisely because, it's even rampant with legitimate screenwriters like Chuck's client, not just unknown people. And the reason is because they get away with it, and they can always get away with it in the courts, 9 times out of 10. I mean, after my Death of Copyright article came out where I listed the 60 cases where plaintiffs had lost in 2010, the studio attorneys told me that they loved that article because hopefully it would scare other people away from filing lawsuits. They know they win all the time. It was the best kept secret for years until my article came out. They knew they were winning all the cases, and they were. They win them every single time. And the reason is, one of the main reasons is, they're applying the wrong test. So,
we'll definitely be arguing about that.
Okay.
But the assertion that 50% of television has been stolen from somebody, I have a hard time swallowing that.
You know what,
and one thing that's also very likely to me is that in Hollywood, broadly speaking, many people come up with similar projects and similar ideas. It's inevitable. And sometimes they even get made into movies about the same topic, competing comets that are striking the Earth movies. And so there's lots of projects going on that have similar ideas, and there may be some, maybe some development executive reads coverage and says, "Well, that's an interesting idea. Maybe I'll add that to my project that's in that general arena." And frankly, copyright law should and does allow that.